Any mention?
Yes.
But I beg to make a mention of item 13, my lord. It is kindly listed after 2 weeks. My lord.
Which other side?
My lord, other side is Union of India. My lord.
Yes.
No objection, Lordship.
Submit on the request made. Mr. Swanson not objected to by the learned counsel appearing with the respondents. Just after
2 weeks.
yes.
Authorized, Lordship.
Acknowledgement.
Please, my lord. My lord, I beg to be mention of item number 12.
Yes.
So I'm praying for 2 weeks.
No objection, Your Lordship.
You are appealing for
For respondent district council, my lord.
district council.
Yes.
You are there.
For the state, your lord.
Okay.
After 2 weeks.
Say the same thing on the request made in the respondent so and so not objected to by the learned counsel. This after 2 weeks.
2 weeks. Obliged.
May it please, Your Lordship. Your Lordship, I beg to mention item number 11.
Yes.
A similar matter is pending before the division bench, Your Lordship, which has a bearing on this matter.
No objection, my lord.
You have recorded that similar matter is
My
pending
lord,
before.
yes, it appears so, my lord.
Okay. Just check the last order. Just check the last order. Let me just send the thing. When shall we list it?
3 weeks?
When is that matter coming?
When the connected matter before the
My lord, that
DV.
matter is coming on the 12th. My friend informed it's coming on the 12th of July. So this matter can be taken up after that, my lord. 1 week after that matter, my lord.
But then whether that will be disposed on that day.
That is another thing.
Anyway, after 3 weeks, then just say. Just say this thing. See these things. The council will answer the connected matter pending. Yes. Yes.
Your Lordship, my lord.
May it please your lordship.
Yes.
Lordship, I have taken consent of the counsel for the petitioner with regard to item number 21, 22, and 24. These are connected matters. We are making a joint request for adjournment.
21.
21, 22, and 24, madam.
Okay. When do you want it?
After 2 weeks, madam.
Yes. Is that all right? 2 weeks.
Yes, lordship.
Just this to all joint request made with the parties. This matters after 2 weeks. Yes.
Much.
Please, lordship. Lordship, this is a joint mention. Item 15, your lordship.
Yes.
Lordship, I pray let this matter maybe come out after 3 weeks, your lordship.
This is a promotion matter, my lord. So,
This is also same after 3 weeks on the joint prayer with the parties.
3
Yes.
weeks.
3 weeks.
Really obliged.
My lord, I beg to mention item number 16, my lord.
Yes.
There is a joint request of the parties, my lord, that may this matter come
And
up
for the
after,
corporation here also, my lord.
So when do you want it?
after 2 weeks, my lord.
This also same on the joint request after 2 weeks. Yes.
Deeply obliged, my lord.
Yeah, please, lordship. Lordship, I beg to mention item number 23, lordship. The one is appearing for respondent, my lord.
Item
23, my lord.
23.
Yes, lordship.
Yes. You are appearing for the petitioner.
Yes, lordship.
There is no appearance for the respondent.
So, lordship.
Okay. Yes. When do you want it?
After 2 weeks, lordship.
23 on the prayer made on the petitioner after 2 weeks. Yes.
Much obliged, lordship.
May it please your lordship. Lordship, I beg to mention item 14. Lordship, in this matter, I prayed for 2 weeks' time.
You are appearing for
District Council, your lordship.
this is respondent number. Which respondent?
3 to 5.
3 to 5. Yes, Mr. Sangwa. What is this matter about?
Yes. I brought a petitioner. This is
What is this matter about?
regarding that suspension. They have suspended. There is no this one inquiry.
The suspension is 2018 matter is pending like that for.
Yes, they have not allowed me to join. They have just suspended
They
without
have
paying.
suspended on certain charges.
Yes, that.
And then no
proceeding is pending.
proceeding is pending for 6 years.
Yes, they have not even initiated. In place of me, they have appointed private respondent. That was the case.
Yes, Mr. Avram, what is this?
Now this municipal board of this Tura Mega
It's a Brahmara.
Bagmara. They are the main respondent, your lordship, in this case.
Okay, that is represented by.
Yes, your lordship.
Anyway. 2 weeks.
Lordship.
And this also you write something on request made by so-and-so, not objected to whether on counsel of the petitioner. Okay? Yes. After 2 weeks.
Yes, Lordship.
I beg to mention item number 19 and 20, my lord.
Item number?
19 and 20, my lord.
20 MD, Your Lordship.
19 and 20.
My lord.
Yes.
These are regarding that quashing of POXO, my lord.
Okay. We'll have it after
2 weeks.
After 2 weeks, when that other matter, when this matter pending before DB is likely to come up? When it is coming up, this matter pending before DB?
13 or 14 or when?
Exactly aware of the date.
That exactly.
This
I
court
do
was
not know,
informed
Your
that it was there.
Yes,
notice back.
yesterday it was fixed. The day before yesterday, my lord.
And then what happened, I do not know.
Lordship. We do not know the outcome, yes.
You should follow it up.
We'll do that, yes, Your Lordship.
Anyway, just you will have it after 3 weeks then.
My lord.
This 1920, after 3 weeks. Just the petitioner. Yes.
And the blades of that.
May I please, Your Lordship? Your Lordship,
Yes.
I beg to mention item number 17, Lordship.
Yes.
This matter can be listed after 2 weeks, Lordship.
No objection, my lord.
Hurry up, Lordship.
On made by Mr. Armaja, Lord at Council, let me with the appellate. Just after 2 weeks. Yes.
Hurry up.
May it please, Your Lordship, I beg to mention item number 25. Your Lordship, the leading counsel is unable to appear today as due to some personal difficulties, Your Lordship. So I pray that it may be passed over for the day.
Pass over for the day.
No objection, Lordship.
We'll have it after. Or next week also may not be possible. We'll after 2 weeks. After 2 weeks.
After 2 weeks. Oh, okay, Your Lordship.
Yes, any problem with this?
No objection, Lordship.
That's on the request made by so-and-so. Just after 2 weeks. Yes.
Obliged, Lordship. Obliged, Your Lordship.
Supplementary cause list. Item number 1.
Lordship.
Yes.
Lordship, this matter pertains to the non-payment of the pending salary of the petitioner, Lordship.
Let notice be issued, my lord. I will take instruction on this.
Why salary is not being paid?
There is no salary, my lord. Gratuity. I will just find out.
Salaries?
Pending
And pending
salary
salaries also is there.
for 34 months, Lordship.
Okay, you are retired, man. You have already retired.
Voluntary retired. I have taken a voluntary retirement, Lordship. On 13/01/2025.
Okay, you have some pending salaries to
Yes,
receive.
Lordship.
And it was sanctioned also.
Yes,
Mr. Day,
Lordship.
it was sanctioned also.
Yes, my lord. So I will just take instruction, my lord. They'll come after 2 weeks, my
This kind of petition, if you have already sanctioned, then you should pay the money.
lord. Only difficulty is, my lord, our situation is very tight.
But
I will just take the instruction, my lord. There is no doubt that we need to pay.
Sanction is made by taking into consideration those things, isn't it?
Yes, my lord.
See, it's recent, it's 18th February 2025.
I will take instruction, my lord. I will take positive instruction. And
MS Jetty Sagmal under counsel for the petitioner. You should notice returnable in 3 weeks. Mr. Yes, Learned Counsel appears for respondent number 1. Appears for all the respondents. And hence, no further notice is called for. Stop. The Learned Counsel for the respondent shall take necessary instruction before the returnable date, list after 3 weeks.
Hello.
Obliged, Lordship.
Daily cost list, item number 1.
Yes, Mr. Sen.
No, this is a revision application challenging an order which was passed by the learned Court of the Additional District Judge in a probate matter, my lords. There's a short issue was this, that after the hearing had commenced in a probate matter, the probate applicant filed an application for summoning a particular witness.
The contested case.
Yes, my lord, contested case. So probate application was filed. I'm for the petitioner. We were on receiving notice. We entered appearance and we filed our objection. And thereafter the trial began. Now, at this stage, as your lordships are aware, under Order 16 CPC.
Court is not aware of anything. Anyway, okay. Yes, proceed.
So what Order 16 prescribes, my lords, that within 15 days of settlement of the issues, if any party is desirous of compelling the the presence of a witness and requires the assistance of the court by issuing summons, we'll file a list of witnesses. Now, in this case, on behalf of the probate applicant, no such list of witnesses was ever filed. They simply brought the deposition of all the witnesses, total 4 witnesses, before the court. Now, after all of that ended, and the matter was posted for hearing, an application was filed by the counsel for the probate applicant, not even the probate applicant. An application was filed to summon a particular witness through the assistance of the court.
And can a lawyer do it?
Cannot, my lord. That was on the ground on which we challenged the maintainability of the
if
application.
you're calling some additional witness, you have to give reason.
Yes,
isn't
my
it?
lord.
So giving reason means it will has to be on factual aspect.
Yes, and the court would have to record its satisfaction
and
on this point.
how a lawyer will swear in an application on behalf
There was no application. I mean, there was an application, no verification, no affidavit.
Then what happened?
So court allowed it. So we're challenging that particular order. Court had no jurisdiction over this matter. And primarily there are 2 issues, my lord. One, that the witness that was sought to be summoned through the assistance of the court happened to be the counsel in the same case.
Is there any bar in it?
In my humble submission, there is a bar. The counsel cannot appear for the same witness. I cannot appear as a witness for the same case.
The person appeared as a counsel,
My lord.
so long he was not a witness. But then once he become witness, then thereafter things is
No, in a probate case, the ground is that he or she was a draftsperson of that particular will. Now, this was always known to the counsel. So the counsel was well aware that there was a likelihood that they would become a witness in this case at some point. Knowing this, they should not have taken up the case.
No, in what
Lordship will examine this point.
Okay.
Only
but then
examine
if you
this
say
point.
so, but then we have to see in what situation the witness has been summoned.
My lord. True.
See, normally, if the attesting witnesses are available, the lawyer who drafted it will not.
Precisely. There were already 2 attesting witnesses.
Probably none of the attesting witnesses are.
No, in this case, both were there. Both the attesting witnesses had already offered their
This
evidence.
lawyer is sought to be examined for what purpose?
Merely because of the fact that he or she is the draftsperson of this particular will.
Which way it has a bearing in that thing? What is the issue?
That has not been satisfied. Well, let's just see the application first.
We'll see. We'll just primarily confine to that order 16 aspect.
Lordship.
We'll just see whether.
Will your Lordship just have a look at...
What is that order? What is that? The impugn order?
May I just take your Lordship the application first?
Yes.
This is at page 39.
There is a talk of compromise also between the parties.
Yes, there was a talk of settlement, but that did not go through.
This fight between close relatives.
Lordship. The deceased mother has bequeathed her share in a landed property to one of the sons to the exclusion of all the other children.
It was her self-acquired property.
No, not a self-acquired, only her share. So whatever she has inherited from her predecessor in interest, that is what she sought to bequeath to one son, to the exclusion of the other children. So therein, that's where the dispute lies. So if your lordships have page 39,
yes,
this is the application that was filed. And please see page 40, that it is signed only by the council. This is not supported by a verification or affidavit. It does not indicate what provision of the CPC it seeks to invoke.
So this is one council signing on behalf of another council.
Another council. And we are saying, my lords, under Order 16, this is not permissible.
Okay, we'll issue notice.
My lords, also just what has happened, I've made a prayer for some interim protection, my lord, because they have already summoned the witness. They've issued summons for the witness.
Where is the impugned order?
The impugned order is at page 44, order dated 5/2/2025.
This order is passed quite sometimes back, Mr.
This year, I've explained the reason for the delay, my lord.
No, but then the date, next date is shown is in the month of March. What happened on 5/3?
So, my lord, I have the list of orders that were passed.
This is a revision under 227.
227, my lord.
Why?
115 is not available to me, my lord.
Why? It is an interlocutory order.
Yes, my lord, it is an interlocutory order. And it will not have the effect of closing the entire proceedings. Proceedings will still remain. So that proviso to 115 will not be attracted here.
The proceeding in this case will mean the entire suit. The
Entire
property.
suit.
Now, even if issue arises out from the main case, it
Lordship.
cannot be treated as a separate proceeding.
Not in my humble submission, no, my lord.
It may not be always correct.
I'm not correct. I leave it to your lordships. So, this is the first order, 5/3/25. So here it was indicated they prayed for time to summon the witness. So steps had not been taken. The next order is 1/5/25. Here they indicated to the court that summon had already been issued, and the consignment tracking report indicated it was delivered, but the witness was still found absent. So far the witness has not been examined before the court. And my lord, the next date is fixed on as per the last order, which is at the order dated 4/6/25. My lord will find at the bottom, the matter is fixed on 9th of July 25.
Okay. Heard, Mr. S. On a counsel of the petitioner, issue notice. Return over the case. The petitioner shall take steps for service of notice upon the sole respondent within 2 days. Have you filed a separate application for
No, my lord. It's contained in the same application at page 9 of my revision.
Just see the Art Learned Council on the interim period. The grievance rate raised in this revision petition is with regard to order dated, with regard to impugned order dated 5/2/2025, passed in test probate case number 4H of 2014. You'll get it in the at case number at page 44. Just get it. By which the learned trial court allowed Summoning of additional witness.
Lordship, additional witness.
Stop. It is the contention of the petitioner before this court that the order was passed in utter disregard to the provisions of Order 16, Rule 1, CPC. Stop. It is further contended that the London Trial Court has acted on the basis of a petition filed by an advocate, who was not authorized to file such application. It is therefore submitted that the trial court resorted to erroneous exercise of jurisdiction in entertaining the plea. Stop. Give a paragraph. Upon hearing the learned counsel for the petitioners and then perusal of the materials of record, it appears that it prima facie appears that no application in terms of Order 16 to Rule 1 was preferred before the trial court. Seeking summoning of additional witness. In view of the above, it is deemed appropriate to stay the further proceeding. It is deemed, in view of the above, at the interim, it is deemed appropriate to stay the further proceeding of test probate case number 4H of 2024 pending before the additional district judge Shillong till the returnable date.
Lodge.
List of proceedings.
Very grateful. Obliged.
So far as the signing of the application by lawyers, especially petition containing assertion of facts, I think there may be some decisions which bars a lawyer from acting that way. Just see.
I'll examine that. Lodge. Obliged.
Item number 2.
This matter, my lords, it's at the admission stage, my lords. This case is about, my lords, construction of a substation for which 95% of the work was already complete at the time when the injunction order was passed by the District Council Court. So, my lords, what had happened is that in 2018, MECL had taken certain lands from the village Darbar of Umtong, and certain monies were paid for the purposes of construction of the substation. My lords.
To whom? Money was paid
To the village Darbar, and so
you got the land from village Darbar.
Village Darbar.
Could you do it? The law allows.
Well, as your lordship can see that that particular document is also on record through the headman, I believe, lords, that execution of the document has been there. And
Is it a proper way of taking over land, especially when there exists a land transfer act?
Yes, my lords. There is a, my lords, sale deed which is there, my lords, at page number 21.
Registered sale deed.
Yes, my lords. Sale deed between village Darbar of Umtong,
yes,
represented through Tribor Mensong Sardar of the village at page 21.
And it has been registered or not?
Yes, my lords. Unregistered.
It has just been notarized. No, even
Notarized. No,
notarized.
I stand corrected. No, it's not registered. I can't see the registration. But this is
now.
Yes, but that is apart.
Then will it be admissible in law?
No, my lords, I understand.
Unregistered sale deed with regard to immovable property. What is the position of law?
That I follow, my lords. I follow registration, stamping of the document. But our issue is slightly different at the point, because what brings us here to your lordship is the injunction order affecting a third party, which is a non-tribal. And there is a pursuant to some arrangement between the Darbar and MECL. There has been construction of the substation, and a significant chunk of the substation is already complete. Thereafter, from 2018 till 2020, there hasn't been any objection which was created. In 2020, there is a suit which has been filed in the District Council Court. An application is also preferred seeking injunction. Now,
injunction against whom?
Injunction against the Darbar and the representatives of the Darbar. Earlier, my lords, because we did not have any benefit of the trial court records being not party, on the first date of the hearing, this Honourable Court, my lords, was pleased to summon the trial court records. And after going through the trial court records, my lords, we were able to identify from the pleadings which were made before the trial court that the entire subject of attack was the construction which was going on behalf of MEC. And the application which was preferred for injunction was also directed towards stopping the construction at the property. And finally, the orders which were passed were also passed by the District Council Court, keeping in mind the construction by MECL. So, based upon that, the orders were passed on 18th March 2020. 2020, the petition is registered on 18th March 2020, the suit, and on the very same date, an injunction order has been passed. And thereafter, my lord, subsequent orders have been passed that first injunction order is applicable in full force. And the latest order which has been passed, which was given to us, was the 17th March 2021 order.
Which was given to you by whom?
By, my lords, the other side.
You were not a party in the suit.
No, I was not. But when my lords labours were continuing with the construction process, they were stopped in between, saying that there is an order of the court which is applicable, and you cannot proceed with the construction. So that, based upon that order which was served upon me, my lords, I approached this honorable court because I could not go to the district council court, I being a non-tribal. And my lords, now the situation is, there's a very interesting point, my lords, because now after, my lords, the amendment to the Specific Relief Act. The amendment to the Specific Relief Act, and after that the orders have been passed. The Specific Relief Act specifically says that as far as matters of energy distribution is concerned, public utility project is concerned, there cannot be any injunction order or specific relief order which can be passed.
That situation was not present before the trial court. Trial court doesn't know that.
But
you were not a party.
I was not a party, my lord.
Creation of involvement of any energy distributor was not there. See, there are two things.
Yes.
First of all, you are trying to establish your right on the basis of a sale deed, which is not registered, which is apparently not admissible in law. If that goes, then where do you stand?
No, I will still stand, my
then
lord.
definitely it is a darbar which is there.
And
if your
darbar is
transaction between darbar and all is prima facie not valid in law, then where do you stand?
No, my lords, I am the representative of Darbar. I am in the shoes of Darbar. I am in the shoes of Darbar. The registration, I have an arrangement with the Darbar. Darbar is also a party here. The Darbar is also a party there. So,
no, but then see, what is your locus before here? You are coming here as an energy corporation, isn't it?
Yes, my lords.
Now, on what basis you are laying a claim on that land? What is the basis of your claim on the land?
My lords, that
even if Darbar wants to make you owner, they cannot.
No,
in
I
view
understand.
Of existence of land.
No, I understand, my lords, that.
Now, see, this is first thing.
Yes.
The second thing is that, even assuming what you say correct.
Yes, my lord.
And his injunction is sought to be executed against you, sought to be implemented against you. Do you want to say that this 227 revision is the solution?
Because it could be, there is no other solution.
No, you are wrong.
My lords, there are two situations here. There are two situations which are there. One is, there is an order
If you
which...
say there is no other solution, just show us something, some authority saying that.
Yes, my lords, I'll show two things, but before that, my lords, I will just place the, because there are huge amount of trial court records, so for the benefit of the court, my lords, I had prepared one compilation, small compilation of the relevant documents, just briefly.
No, see, documents we'll see once we say that the documents becomes admissible.
No,
according to this code, unregistered sale deed will not confer.
No, my lords, I am not showing the sale deed. What I am showing your lordship is the pleadings before the trial court. That it is directed against a non-party.
Even if it is there.
It is directed against
if it is not there.
Yes, my lord.
How is you can come under 227?
I will demonstrate.
Let us assume that you are factually correct.
Yes, my
Let
lord.
us assume that was an indirect. You see, like it was a ploy by the other side.
Right, my lord.
To basically to cause problem to you.
Yes, my lord.
Now these are all factual aspects. How 227 court will take?
I will demonstrate that, my lords, because it is absolutely clear how the jurisdiction of this court will become clear, and there is, my lords, also an order passed by the concurrent bench in a similar, my lords, matter. So, this, my lords, compilation, a very small compilation of 40 pages.
Yes.
Yes, my lords. Just briefly, my lords, and then I will, on the basis of these documents, I will demonstrate how 227 is maintainable in this case. So, my lords, yes,
show us the order of injunction which affects you.
Yes, my lords, this is that is also there in this
Please
compilation.
show us that. Without going into all those things. You see, I don't think that these.
Your lordship can see the order of the injunction directly. I will not, your lordship, take your lordship
Where
to
it
other
is?
things. Your lordship can come to page number 18 of this compilation, lords.
Page 18. If that is not appended with the revision application, that injunction order.
My lords, we were not served.
You said that somebody has asked.
No, the injunction, the initial.
Order, the subsequent order, my lord.
I was served, my lords, with the subsequent order, which says that the initial order is in operation. But your lordship has to see the initial order first. So this order was not given to me. Only when the trial court records have been summoned that this order, I have been able to lay my hands upon this order.
Yes.
18, page 18, my lords. This is 18th March 2020. And it says that instant application is endorsed to my file for disposal of order of the learned Judge District Council on the body of the petition, so and so, my lords. Next page, your lordship can see. Learned counsel for the petitioner moved the instant application and submitted that the petitioner and the opposite party number 1 herein are the only surviving legal heirs and successors of late Brill Minsong. During her lifetime, late Brill Minsong was the lawful owner and in exclusive possession of 2 different landed properties situated at village Umtgam and Nong Pirdi village, known as so and so. The suit land, my lords, the description is thereafter given on the next page of the suit land, and thereafter it goes. It is further submitted that the headman and the general secretary, because there are specific allegations against MECL even in this order. Headman, general secretary of the so and so village have issued a certificate to affirm that the petitioner and the opposite party number 1 are the joint and rightful legal owner of the suit land, in as much as also affirmed that the petitioner is entitled to half of the suit land. It was in the month of December 2017. The petitioner, along with his family members, visited the suit land. And during such visit, the petitioner was shocked to find some 3 to 4 laborers of MECL were trying to develop the suit land for the purpose of to set up a powerhouse. On inquiry, he was informed that they were permitted to use the suit land by the opposite party. Furthermore,
So your involvement comes here.
Yes, my lords.
That is a fact. The court was aware that
Yes,
some MECL laborers were engaged there for the purpose of developing the land.
Yes, my lords.
In order to establish a powerhouse.
Yes, my lords.
So you become.
Yes, my lords. Yes, my lords.
Yes.
My lords, at the very outset.
This,
we have
if
raised
that be the
issue.
thing, then
My
the
lords.
district council court could not have exercised jurisdiction.
No, my lords, here. If lordships can have the plane again.
Now, what you will say about this? This has come from your own submission.
My lords.
Then
Your lordships
then
can
becomes undisputable by that you.
My lords, again, your lordships can have page 6 of my friend's compilation. This is the prayer before the district council. Page 6
of
the compilation. My lord, the prayer portion. Here, firstly, my lord, we have prayed before the learned court a declaration that the plaintiff and the defendant number 1 are jointly the lawful owners of the suit land, and that the said plaintiff and the defendant number 1 have absolute right, title, and interest over the suit land. Secondly, a declaration that the defendant number 2 has no right, title, and interest over the suit land. 3. A preliminary decree of partition of the suit land by meters and bounds of allocation of half share thereof to the plaintiff, being his rightful share therein of the share of the plaintiff. Next page, my lord. A direction of the office of the to the office of the Kairam Sameship, East Castles, Meghalaya, to survey and demarcate the suit property and allot to the plaintiff his share therein, and submit a report to this honourable court in terms with the preliminary decree. A final decree in terms of the report, with the report of the Kairam Sameship, East Castles District, Meghalaya. Perpetual injunction restraining the defendants, their employees, agents, associates, representatives, or any other persons claiming through or under them from interfering with the peaceful possession and occupation of the plaintiff in respect of the portion of the suit land so parted to the plaintiff, and also from entering and trespassing such portion of suit land, and further from dealing with the suit property in any manner whatsoever. Here basically a suit was filed for declaration, partition, and for permanent injunction. No, my lord. But the question here, which arose, my lord, whether orders passed by the civil court is amenable to writ jurisdiction under Article 2 to 7.
If there is,
my lord, I'll come to it.
Jurisdictional error.
No, my lord, here lordship is very much aware.
Because he is not a party, he cannot come under 115.
My lords.
Now, so far as the order of the court is concerned, that appears the trial court was made known or was aware of the fact that the land
Certain
was
to the effect that some
occupied
laborers
by-
were, some
it was
laborers were, yes.
occupied by some MCL things. So that way, that view of the matter, MCL became party. Of course, may not be this thing. At least one thing, the court was aware that there is involvement of a party who is not subject to the jurisdiction of that court. We'll admit this thing. We'll list it for hearing.
No.
See, initial reaction. See, this court is basically not in favor of entertaining 227 revision application in civil things. Statute is there, law will take care. The constitutional power cannot be resorted to for all small matters. Now, to be more precise, you see, 227 is supervision of High Court over the subordinate courts. It is not for the purpose of implementing individual right.
Yes.
227 cannot be resorted until and unless you can show that the court has travelled beyond its things. Now that is what. All along Mr. Pandey was at the receiving end because of that. Now today he has shown something. We'll admit it.
No, Lordship, I'll satisfy Lordship this time here.
You are appearing for the Darbar?
No, my Lord, for the respondent
Who is
number
Darbar? Yes. What is your contention here? You have no objection, but then if you have allotted the land to them,
they are the ones.
Why you are not defending their rights? Very surprising. You are happy to get your money. Huh?
In fact, my Lord, they admit the fact that the land which was sold.
You should have that was for you to raise a plea that this MECL becomes a necessary party there and court had not have raised it. And they are also not protecting you. It could have been simpler that had there been filing of application. Though thing is that prima facie you feel that okay, maybe you are not sure that finally what you will get here.
Right.
Some other issues may come up. Some other question also. May come.
Prima facie,
speciality, availability of other remedies.
Yes.
This court doesn't agree that this is the only remedy. At least this much.
Well, I appreciate this.
Probably you also will agree outside the court, not here. Yes. Heard Mr. Pandey, Learned Counsel.
My Lord, if I may.
Yes.
My Lord, I am respondent number 6 here, Power Grid Corporation of India Limited. I am the.
You are opposing his pair.
No, my Lord.
Yes.
My Lord, I have a slightly different stance. Obviously, my Lord, I am supporting their cause. My Lord, I am exercising powers under the Telegraph Act, my Lord.
Yes.
By virtue of Section 164 of the Indian Electricity Act, whether my own or theirs, since I am the implementing agency of this project. Now, my Lord, yes, it is a fact that this is a project of national importance, and this project is something which is running into several hundreds and thousands of crores, partly being funded by the Asian Development Bank. Now, my Lord, these are institutions which come to finance for the good. Now, my Lord, coming to the core issue, since I am exercising powers of a telegraph authority, if we read section 10b, 10d, and my Lord, section 16.4, it will be abundantly clear, my Lord, the dispute as to who is the owner is secondary, my Lord. In exercise of those powers, in the establishment of a transmission system, my Lord, I can enter upon any private land, establish the transmission system, and whatever is the compensation that will be paid.
Does it mean that you can enter anybody's house just like that?
My Lord,
there must be certain situation prescribed under law.
There is, my
certain
Lord.
procedure prescribed.
My Lord, there
but then
is.
here the situation is something else.
So, my Lord, my prayer.
Here the situation is something else. The claim is based on a sale deed.
My Lord,
it is not that see, like you are basically constructing something. You are what do you say?
Transmission system, my Lord.
Yes, maybe.
Transmission line?
Something like that, and then some obstacle comes. There you have the power. But then that is, here it is not that. It is not.
My Lord, Century Textile has, if I may,
Anyway, we'll see to it. Since you are not opposing his prayer.
My Lord, my humble prayer is, my Lord, this substation is an integral part of this transmission system. Now, I may be allowed to continue with my work. Why? Because, my Lord, if we can just glance section 16.4.
See, the order, this LC record has been called for.
My Lord.
So that is matter now stands seized here. What remains there? We'll admit it. See, this.
My Lord,
we'll admit it for hearing.
The work is stalled. My Lord, if I can only read 16.4 for the benefit of the court.
If you say that if you want some effective order passed, then you have to enter into the everything, and then. We are for admission here. Prima facie, Mr. Pandey has satisfied that, yes. So
My
we'll
Lord.
admit it.
No, because the work is stalled, and this is work for a larger public good. It is It has to.
See, work is told is until and unless you can establish. See, then again the question of thing will come. Now, if you say under the Telegraph Act, you have the authority to enter anywhere and do anything what you want, then so then you establish. Then if you say you want to argue before with it, then we are ready for
My
that.
lord, the law on that is the law on
But
that.
in what situation that is?
My lord,
Does it mean that you will not notify the person concerned? Have you notified?
My lord, this land was given to us by MECL.
That is where, how it is given, that is the question.
My lord.
Now, if you enter in that question, then you will be in a in more problem. Tell us how this cell deed can be this thing. MSCB can give it once they have the authority.
My lord. My lord, the public good over here, or the construction is
I
stopped.
believe, my lords, your lordship is admitting it, and my lords, a shorter time period may be set for so that the matter can be, my lords, decided. I think that will be, my lords, in the interest of all the parties. And then instead of, my lords, your lordship is not.
You activate your darbar, and then the entire problem will get solved instead of having so many technical difficulties.
Yes,
especially this, before this court.
Right.
You may not have that difficulty before any other court. Okay?
Yes, yes.
So this court will satisfy
No, my lords, it's absolutely
itself
correct.
fast into the question of law.
Yes, yes.
Would not like to pass or assume jurisdiction where law doesn't permit it.
I bow down to that.
My lord, in that case, on the next date, my lord, I will, from my stance, my lord, the Electricity Act also in principle states that the lower, any civil court, my lord, may
See,
not
first
grant
of all,
any injunction.
Is this an application by you?
No, my lord.
Now, if you say that if you are aggrieved by the passing of the order of the district council, then it is for you to challenge it.
My lord.
If you say that you have separate identities, separate locus standi in this case,
My lord.
then you challenge it separately.
My lord.
Then you raise this
my lord,
question.
I'll endeavor
Here you
to.
are a respondent, isn't it?
My lord, I'll endeavor to only satisfy to a point that if the lower court, the trial court, my lord, if the civil, they knew that there is the electricity department is engaged, or there is some, what my lord has observed while admitting it now, then the Electricity Act says, my lord, it discourages granting of any stay in projects.
We have not said anything. We have not made any observation with regard to the existence of any project.
My
We
lord.
only said that the very involvement of laborers of his shows that the land was in his possession.
My lord.
There he suffers.
My lord.
Only this much. Not beyond that.
My lord.
We have not gone to that extent to see whether he was there for the purpose of execution of a project or not.
My lord.
Okay. And if you say that while you are drawing a line as an emergency line or all, you have different objection, then you have a remedy under different section. 227 is not. Yes, heard Mr. Pandey, Honorable Counsel for the petitioner, and also Mr. Sangma, you are for?
Respondent number 1.
Mr. So and so. Mr.
Respondent number 6, my lord.
Okay, you are 6. You are welcome, and you are for. And then what about 2, 4, and 5?
So they are yet to appear.
They yet to appear because they haven't appeared.
They have been served.
They have been served. They have been served, and an affidavit of service, I believe, was also filed. My lord. Yeah.
Who are they?
There's 2. I will is.
My lord, 3 and 5, they are the different post holders in the Darbar
Post
Shnong, my lord.
yes, my lord.
My lord, 3 is the.
They are not represented by you. If they are represented.
3 is my lord's village
3
darbar.
is the Darbar Shnong, my lord. 4 is the headman,
Headman.
and 5 is the general secretary.
Okay, you have made a service, personal service, Dasti service.
Yes, my lord.
Okay. Just say so and so, so and so, so and so. Just say there is no representation on behalf of the respondent number. 2, 3, respondent number 2, 3, 4, and 5, isn't it?
Yes, my lord.
3, I for 3.
You are for 3. So then it should be
4 and
My lord,
5.
2, 4, and 5 have been served but unrepresented.
That is what, there is no representation. That is what we see. Just say, admit this petition. When shall we have hearing?
After 1 week.
After 1 week in
Make it
March. After 1 week. Possible.
My lords may have it on 9th, my lords. I will be physically present. So, on 9th, if your lordship's calendar permits. Right.
No, that is. See, what situation would be there tomorrow that we also do not know. See, since you have to shuttle, from.
Yes, my lord, yes, that is the
So we
only
do not know
way.
where this
Yes.
is. Anyway, you can. 9th
So
will be
tonight is a
problem.
Wednesday, so there's a division bench. I think I have some matters.
So 8th, my lords, 8th,
8th or the 10th, no?
8th or 10th, whatever your lordship finds it convenient.
I think 10th will be.
10th.
10th is.
10th.
Is it?
My lord, I'm for respondent number.
Make it on. 8th is better. Oh, make it on 8th. We'll have it on 8th.
My lord, I'm for respondent number 6. I was impleaded on the previous occasion.
That will be recorded, yes? Yes,
Power
Mr.
grid.
So-and-so. Yeah. Court will definitely record you.
My lord.
Court may not go by your submission, but then your name will be there.
My lord.
Oblige me.
I'll oblige, my lord.
Item number 4.
May I please, Lordship?
Yes.
I pray that the matter may be taken up after 2 weeks, Lordship, since conducting counsel is on sanction leave.
What is this?
Condonation.
Okay, condonation of delay.
Yes, Lordship.
Yes, you have objection to the delay condonation. You have filed your objection.
I have already. Last occasion, Lordship expressed a view regarding the merger also. The earlier order passed in substitution petition on 12/7/2019. They clubbed together with the recent order of.
It's not clubbed together, Lordship. It's what?
But last night, Mr. Devnath informed that some person has expired in his family.
That is all right. But if there is a delay of only 18 or 90 days,
No,
why?
Lordship. Since 2019. There is no merger because the last order was passed in the review petition. That is dismissed. That was rejected, not on merit. If it was on merit, then it should be merged.
What is the order challenge in this revision?
Both the order, one order passed on substitution petition on 12/7/2019. Subsequent order on 9th of 12/2000 in review petition.
Order passed in a suit.
No, there isn't one land acquisition matter, Lordship.
Yes. Land acquisition matter.
Yes, Lordship.
And then which way you are? This is a.
I'm the private party. The reference was made between.
That is a reference under section 30.
Yes, Lordship.
If I can.
Apportionment.
Yes, Lordship.
If I can explain, my lord, there was a land acquisition matter, my lord, that is LA case number 117 of 2015.
Under the earlier act, the old act, yes.
And in that case, my lord, Sri Ojendra Kharsandi, one person by the name Ojendra Kharsandi, he was the claimant in that proceeding. During the pendency of that proceeding, my lord, this Ojendra Kharsandi, he expired. On his expiry, my lord,
land acquisition case, by saying land acquisition case, you want to say, you mean the reference. There is a reference.
There was a reference.
Under section 18 or
yes,
section 30?
Under section 18, old act, my lord.
So that is with regard to dispute.
Dispute.
Or apportionment.
Right.
So it was referred
Before the reference commander or special judicial officer. And then during the pendency of that proceeding, my lord, this Ojendra Kharsandi, he expired. And on his expiry,
he was a claimant there, or he was the opposite party. Claimant.
He expired. On his expiry, my lord, the present petitioner herein, my lord, they have filed a substitution petition before they filed an impleadment application, my lord, before that reference court. And in that reference proceeding, my lord, while taking up
substitution or impleadment?
No, both petition. In this same petition, they mention about substitution and impleadment.
You are the opposite party before the proceeding.
I am the claimant.
Before the special judicial officer.
Yes, I am the claimant also.
And my lord, thereafter.
We have not. How can?
Yes, Lordship.
There is a dispute between two, isn't it?
Yes, first because
so you both are
one portion I have already got my compensation.
Yes. Okay, maybe
in one portion on only 105 meter of land they claim now.
My lord, the main issue is, my lord, there was a LA proceeding, my lord, and in that proceeding, this late Ojendra Kharsandi, my lord, he was a party. He expired. On his expiry, my lord, the present petitioner here, my lord.
In that proceeding, who was claimant and who was the opposite party?
Claimant on 117, I am the claimant.
Yes, Ojendra Kharsandi also, my lord, was a party to that case, my lord.
There are two proceedings pending,
yes,
or what?
Yes, yes. One proceeding, my lord, they have, I think this was and you also your party claimant. Both.
They both.
Yes, both were party, my lord. And thereafter, in that proceeding.
Party as what thing? As what? On which side?
Claimant, my lord. They were claimant. They filed their claim petition.
They also filed claim petition. I also filed.
Yes.
That is okay. That is how the dispute comes.
Yes. And then in that proceeding, my lord, what happened? The present petitioner, my lord, herein, they filed an impleadment/substitution application there. That was rejected by the special judicial officer. Against that order, my lord, rejection of the impleadment application, my lord, they have filed a review. That was beyond the prescribed time limit, my lord. And
the review was barred.
Review was barred. And the review was ultimately, my lord, dismissed by the...
on merits?
No,
not on...
barred by limitation.
Limitation.
On maintainability?
Yes. And then that was, review application was also, my lord, dismissed. Against that review applications, my lord, they have come before this court.
No, but in
that
both
order,
the orders. Both the orders.
They have challenged that order passed in the review, as well as, my lord, that earlier rejection of their impleadment application.
Yes, so what is the problem in it then?
It cannot be merged. That order of
It is
2019.
beyond the statutory limit, my lord, that was provided. Way beyond, my lord.
Limitation will be counted from which date?
My lord,
2019.
from the, as per the Limitation Act, my lord, it is from the date of the
Any
order.
law in this regard?
Well, Limitation Act is clear.
Say supposing, let us assume, that after a review is filed, and if it was allowed, then what would be the situation?
Then it will be merged. It is there is some judgment of the Supreme Court, not in specific, but in some cases it is mentioned about that. Merger will come on merit. If it is not on merit, then the subsequent order cannot be merged.
There may not be a specific is a like question of merger, but then when it comes to the computation of period of limitation, from which date it should?
Because they have challenged two orders.
See, normally if a review application is filed and if it remains pending,
Well, they have filed the review application without the application for condonation of delay.
no, that is what
On
this could not have been
technical ground,
entertained.
They have dismissed the application.
And not on merit.
Yes, in such a case, they cannot get the benefit of it.
Right.
Yes.
That period either cannot be excluded. Is
Yes. That order
Yes,
passed in the substitution or that impleadment, they attain on in finality.
Yes. When shall we have it?
After 2 weeks, Lordship.
Fixed date, maybe fixed, Lordship, otherwise.
You take the date with this thing. Take from
11 to.
you just see. You have to not only suitable to you. It should be suitable to us also.
Yes, I'll.
Just see with her and then this.
Yes.
Give her a date, whatever the possible date. See? Okay, on prayer made by, but then after 2 weeks. Yes, on prayer made. Just wait. Let us pass the order.
Oh, this one.
What is not passed the order?
Sorry.
We have only agreed to give you a suitable. Yes. This is MS. You are. What is your name?
B. Malnyang, Lordship.
Learned Council. Yes, made a prayer on. Yes, so and so Learned Council. Praise for. Just say, you are an advocate on record, or you are just mentioning on behalf of Mr.
No,
Devan?
I'm on record, Lordship.
Okay, London Council, they're praying for the petitioner prays for grant of some time on the ground of non-availability of the argument counsel in the matter. The same as M. Dev. Mr. Srinkan, you were there. Okay. London Council appearing for the response so has no objection. Prayer alert. Then you say list on. Just take the date from there. Yes.
Item number 5.
Yes.
Your Lordship, this matter pertains to the judgment and order in a suit.
Very complicated matter. Yes.
Your Lordship, on the last occasion, had stated that under Article 227, whether there is any authority or duty, of the High Court to interfere if there is any glaring error in the judgment. So here the judgment itself is perverse and it's patently erroneous.
What is judgment? Is which judgment passed by whom?
Judgment of
Judgment
the
passed by which court you are challenging here?
by the district council court. By annexure
District
10,
Council
page
court?
79.
What level? The court of?
Additional assistant judge.
That is the court of first instance.
First instance, but in the district
So,
council, the
from-
court of second instance has dual charge. He is the secretary of the council as well as
No, secretary on the administrative side, isn't it? So far as the judicial duty is concerned, judicial function is concerned, so that is a court of first instance, isn't it? Now, above assistant judge, who is the authority? Where appeal lies from the order of assistant judge?
assistant judge.
From the order of assistant judge, if any appeal or revision is to be preferred, where it will be filed? Before which court?
Before the additional judge.
Oh, judge or additional judge, isn't it?
Additional judge.
It is something, is it the constitution of court is something, you say like similar to the constitution of court here in the Khasils or
No.
District Council?
No. Here, there the district judge who happens to be the additional judge also.
District judge happens to be the additional judge?
He's the additional judge as in a civil suit. This is against the civil suit, Your Lordship. So it would go to the additional judge only.
Additional judge and
He is the
and just
assistant
concurrent
judge.
power of the judge, isn't it?
Assistant is the court of first instance. There is no court of second instance there.
That is all right. We are not asking about the second instance. We are just asking where normally an appeal will go against the order of assistant judge.
Will go before the district judge.
Judge district council. If you say district judge, that becomes
The nomenclature is district judge. Yeah.
district judge, district council.
Yeah. Here also the nomenclature is assistant judge.
District council.
Yes.
Isn't it? Okay, now this is, if it is a court of first instance, then if it is ordered by the court of first instance, why you are here under 227?
Your Lordship, I would like to just take you to the order first. At page
Just tell us
79.
why you are there. Why you are there? We'll come to all those.
Your Lordship, here my prayer is very limited, Your Lordship. There is a clear, the order is perverse.
See, Mr. Raske, just before we come to prayer, just tell us why 227 be jurisdiction be exercised here.
Your Lordship, the judgment of Shalini Shyam, Radheshyam, the judgment which the learned court is well aware of, clearly speaks that it's a patently erroneous judgment. This Honourable Court has, under supervision of Article 220, has the power.
Probably there are more recent judgments about entertainment of petition under 227,
But
when there is a specific provision of law. Well, we may say that there may not be a complete bar, but then we can say that there is a near total bar.
a total ban is not there, Lordship.
We say near total ban. Now, to avail that, you have to, show the existence of certain situation where 227 can be resorted to. Now, what are the situation in this case?
Your Lordship, I'll take my Lordship to the judgment first.
Yes, yes, why not? Yes, you are ready.
Your Lordship, before my senior start, Your Lordship, kindly this matter may be listed after 2 weeks, Your Lordship. The conducting counsel, Mr. A.G. Mohammed, is still indisposed, Your Lordship.
What happened to him? Why?
He's not, Your Lordship, he's having flu, Your Lordship.
Are you challenging the maintainability of this
Yes,
case?
we have an objection on the ground of maintainability.
Yes. Yes.
Yes, sir.
What is your reaction to their prayer?
No, somebody is indisposable and sick, Your Lordship. I have no objection. At least they should have informed me earlier.
You are also there.
Today, yesterday we are here from Tura.
weeks, Your Lordship.
Up to 3 weeks, Your Lordship.
This one clear. Made by the learned counsel for the respondent. This is made after 3 weeks. Yes.
Item number 6.
Lordship, I have filed my power for respondent number 2 and 3. I have filed my power for respondent number 2 and 3.
This is a petition for quashing of an FIR.
This is again a POXO matter.
No,
No, Lordship.
attempt to
It's a-
murder. Attempt to murder.
307.
307.
But in a new law, BNS, 180.
109 and 118.
That is a recent case.
Yes.
Yes, Your Lordship.
Okay. Yes.
Lordship, may kindly call for the record and fix for hearing. Kindly call for the record
Record of?
of the case.
This has been charge sheeted.
No, no,
Then?
no, Your Lordship.
Now you are seeking quashing on the basis of some settlement.
Yes, Lordship.
They say that it's a family matter.
Now, is there any settlement deed made?
Yes, Lordship, there is a settlement.
And that is made a part of this record.
Yes.
Yes, Lordship.
You have your instruction.
Yes, I do. But the thing is, Your Honor, if it's an attempt to murder, then it's a serious, grievous crime. Then we should see how, between family members, can you settle something like that? We need to see. There are certain judgments which
Just
say
because
that we can.
307 is involved, will there be absolute bar in settlement?
No. No.
You know that very well, probably.
We will have to
Then
rely
we'll
on
examine,
certain
we'll just
judgments.
enter this thing.
Yes. We'll have to rely on certain judgments.
Yes. Just say, Mr. So-and-so, learned counsel has entered appeared on behalf of respondent number 2 and 3. Will you sit for hearing then?
Yes, Your Lordship.
And so-and-so, and hence the service is complete in this matter. Stop. Just next paragraph, sir. Let's straightforward with the parties. List this matter for hearing after 2 weeks.
2 weeks.
Your Lordship, humble submission. I'm not here on Fridays, any other day. I will take a date. I'll ensure.
7.
Obligation.
Please, Your Lordship. Lordship,
Yes.
we have received instructions, my lord. We are on the process of drafting the reply, my lord. Kindly, if 2 weeks' time is granted to us.
This is what service benefit for.
No, not service benefit. I am under indefinite suspension, my lord.
Yes, respect for the MS Sanjay Shilla, learned senior GA. How much?
3 weeks, my lord.
3 weeks time granted for filing counter affidavit.
Okay, please.
Hearing item number 10.
Yes. Yes, madam.
My lord.
This is a writ petition.
My lord.
Yes.
This matter, my lord, pertains to the subsidy under the Northeastern Industrial and Investment Promotion Policy, my lord. Here, my lord, we are claiming the capital investment subsidy, my lord. So, my lord, may I start, my lord?
Yes, yes. You are entitled for subsidy.
My lord.
And that was not granted to you.
My lord, we have claimed around 44 crore, my lord. Around 29 crore has been released, but the remaining, they have not released it.
So it's a basically dispute with regard to the amount.
Balance amount, my lord.
No, balance amount means the assessment is to be by them, isn't it?
My lord, the state level committee has approved it, my lord. After approval, it has been sent to the ministry, my lord.
The state level has approved the amount which you claimed.
My lord.
And thereafter the center reduced.
Central has some objections to it.
Are you saying that they are not the rightful authority to do it?
My lord,
Is it your contention that they are not the rightful authority to reduce the amount which is recommended by the state or forwarded by the state?
My lord, they can do it, my lord, but they are saying that the bricks and then other materials for the civil work, they are saying this cannot be included in the plant and machinery, my lord. That is the ground they are taking, my lord.
Now, how we will decide it, whether it should be included or not included in the writ petition?
My lord. My lord, because the internal audit wing also has given their approval to our subsidy, my lord, the entire amount.
Yes.
Lordship, learned senior counsel is on legs before division bench, Lordship.
So what is to be done?
Lordship, if you can reply on the next day.
We'll do it on the same day.
Lordship, then I'll pray for 1 week's time, Lordship.
What is the stand of the union here? Have they filed an affidavit?
My lord, they have filed their affidavit.
And what they say in their affidavit?
My lord, in their affidavit, my lord, they have brought on record on subsequent notification where the plant and machinery has been defined. So, in that definition, as
So
part
they are justifying the rate given.
my lord, they are saying that the cost of mining equipment should be excluded for calculating the subsidy, my lord.
Now
Since
there
it
exists
is not an integral part
there
of
is
the
a scheme, isn't it?
My lord.
Now,
My lord, in the main scheme, my lord, that there is no definition for the plant and machinery. This has come on subsequently, my lord.
the method or manner of computation, is it prescribed in the scheme?
No, my lord, that is not there.
Then you go by civil suit, file a case. If there are disputed question, then it will be a problem for us.
This is my lord, the next state, my lord.
Just saying, we are suggesting, we do not know, we are yet to hear you. Because the scheme is still, it's in subsistence.
My
It's-
lord, my
it's
lord. It's a 2007 scheme, my lord.
Okay. One prayer made on behalf of Dr. Majika Learned You have any objection to her prayer?
No, my lord.
DSA, appearing for the respondents. This is quite old matter actually.
My lord, this is 2014 matter.
Not objected to. But, sir, this matter after. After, yes, next week will go after 1 week or after 2 weeks? What will be okay?
After a week, my lord.
After 2 weeks.
My lord.
Yes.
18.
Is he a local counsel, Chakrabarti, Mr. A. Chakrabarti, or somebody is there in the order? Last occasion he appeared. Anyway, sorry.
My
Yes,
lord,
Mr.
just to recapitulate the matter, kindly may I draw my lord's attention to order dated 26th of May, my lord.
This is, what is the matter?
My lord, this is this
Just a minute, let us see the order.
26th of May, my lord. May I just read from my lord has got
Just
the
let
order.
us just find out the first order. Yes.
26th of May. My lord. It appears that the production of the inquiry report dated 20/07/2022 shown to have been enclosed with the FIR dated 10th of May 2024 in Sadar case number is necessary for proper appreciation of the case. The learned double AG appearing for the respondent shall place a copy of the said report on dated 20th/07/22 on the next date of hearing, my lord. So now, my lord, the learned double AG was directed to place the record on record, my lord.
There is no appearance. You are there.
My lord, Mr. Sula is there, my lord. He is on leg, my lord, in the.
So, I think perhaps this is the last matter. So let it next week, my lord. Any convenience to my lord.
You do not know this. You have to depends upon the. Yes, sir.
My lord, we have received the report, my lord, in this case.
Yes. You are ready for hearing?
My lord, however, Mr. Andy Shula AG is on legs, my lord, before DB.
No problem. Possible, when can we have it? 1 week or 2 weeks?
2 weeks, my lord, 2 weeks, sir.
Just say on request meet. On behalf of Mr. Andy Shula, none at AG appearing for. the respondent. This is met after 2 weeks. Yes.
To oblige.
28.
Yes.
The private respondent is not represented. There is a compromise between the private respondent and the.
This is a land dispute, Your Lordship.
So then private respondent becomes.
He was there before.
Let's say so and so is present behalf of petitioner. Mr. J. Gurung is present on behalf of the state respondent. However, there is no appearance on behalf of the respondent. When shall we have it? This next week. There is no slot.
2 weeks, sir.
Yes.
Reply.
List is met after. Now there is no appearance as per the parties. This is met after 2 weeks. Yes.